I'm Amanda Sellers.
And I'm Jenna Finkelstein.
And we are the attorneys of Powers, Sellers, and Finkelstein.
Welcome to our ongoing series of informational videos where we discuss Florida statutes and your rights under the law.
The definition of stalking and the penalties for conviction in Florida. Along with domestic violence, stalking is a crime that was not prosecuted aggressively until recently in Florida and around the country. Victims were often thought to be exaggerating the circumstances or labeled attention seekers. Lawmakers across the country, including the state of Florida, now see stalking as a serious, potentially deadly crime. If you have been accused of stalking in Florida, it is essential to understand the Florida stalking laws and potential penalties for a stalking conviction. Under Florida Statute 784.048, subsection 2, the criminal offense of stalking is defined as follows. A person who willfully, maliciously, and repeatedly follows, harasses, or cyberstalks another person commits the offense of stalking. To fully understand the definition of stalking, you need to know how some other important terms are defined, such as harass and cyberstalk. Harass means to engage in a course of conduct directed at a specific person which causes substantial emotional distress to that person and serves no legitimate purpose. Cyberstalk means to engage in a course of conduct to communicate or to cause to be communicated words, images, or language by or through the use of electronic mail or electronic communication directed at a specific person, causing substantial emotional distress to that person and serving no legitimate purpose. Stalking is charged as a first-degree misdemeanor absent aggravating factors and is punishable by up to a year in jail and up to a $1,000 fine. Aggravated stalking is charged as a third-degree felony and is punishable by up to 5 years in prison and up to a $5,000 fine if any of the following aggravating circumstances are present. The accused made a credible threat during the alleged stalking behavior. The accused also violated an injunction or other court order requiring the accused to stay away from the alleged victim. The alleged victim is under 16 years of age. If you have been accused of stalking, you must take the accusation seriously. Not only do you face a potential term of incarceration if convicted, but a conviction for stalking could also adversely affect your rights to custody or visitation with minor children. If you believe you are a victim of stalking, you have the legal right to request an injunction, which, if granted, will order the alleged stalker to refrain from contacting you or harassing you. In either case, it is in your best interest to consult a Florida criminal defense attorney for immediate representation.
Thank you for your interest in our informational video series.
If you or someone you know is arrested or accused of a crime,
Call us or visit keepcalmcallus.com for immediate representation.
And be sure to text ARRESTED to 63975 and add us to your phone's home screen.
We'll be just a tap away when you need us most.